counsel for the defendant, Assistant State Attorney. Mr. Mason, are you or Mr. Baez going to be handling this? Okay, Mr. Ashton, would you point out the particular statements that you feel meet the definition contained in Huggins versus State, and why are those statements operatory? It may take you a little time to find it, since the pages may or may not be the same numbered ones that we got last night.
Well, upon review, let me just say, first of all, that we'd like to thank Ms. Peters for her extraordinary efforts in getting this to us overnight. Upon review, the statements we were concerned about appear at page 79 of the transcript. Pardon me. One of the, this has to do with the putative father of Kaylee, Mr. Baker. This is all material that was not discussed by the statement. I'm prefacing that by saying that if this is offered in the context of simply another one of the defendant's false statements, then we would withdraw our request, because obviously the defense is not asserting that she's credible. The reason that we were somewhat concerned about it was that the court had previously ordered that any hearsay statements were to be proffered, and since that wasn't done, we don't really know the purpose for which that's being offered. So if the defense indicates now that this is not being offered for the truth of the matter asserted, but just as another one of her false statements, then we would withdraw a request. We'll leave the J&S marked. If it comes up again, we'll address it then. The defense now is aware that we have Huggins in our back pocket. But so if they indicate that that was its purpose and it's not for the truth of the matter asserted, then the issue is moved.
Dealing with these imaginary people who was dealing with, but Mr. Mason?
I think you also just asked, is this the only page that you all decided to?
Well, the
issue for the 16th.
There were other areas that were additional facts, for instance, about Jeff Hopkins, etc. I take it from the context that all of these statements were being offered in that same vein. So, I mean, I would add to Jeff Hopkins, but it appeared that was all starting at page 79 and going on through all the discussions about Jeff Hopkins at through 83. You know, and I'm not waiving any argument we may have later to go back and find a subsequent statement, either from this witness or another witness, and reassert the issue. But for today's purposes, our concern was Mr. Baker and discussions about Mr. Hopkins, and whether any of that was actually asserted by the defense to actually be true, particularly as to Mr. Baker, because Mr. Baker, as we know from the investigation, the actual paternity of Kaylee is something that has never really been determined. Obviously, we don't know from the evidence whether Mr. Baker is in fact Kaylee's father. We suspect he may not be, but nobody really knows if Mr. Baker is deceased. So,
my questioning on this page would be related to, as Mr. Ashton forecast, the additional continuing lies. It has nothing to do with the exculpatory statement in that regard. The 16 would not apply. Now, I agree, there may be other times later on in the case when we would revisit this again. But for now, I think it's right to withdraw that request.
At this time.
The only thing I'm going to say is the following. Please read Florida Statute 90.806, paren 1, which reads as follows. When a hearsay statement has been admitted in evidence, credibility of the declarant may be attacked, and if attacked, may be supported by any evidence that would be admissible for those purposes if the declarant has testified as a witness. Again, the case of Huggins versus State, a 2004 Supreme Court of Florida case found at 889 7 seconds 743. Also, Fisher versus State, which is found at 924 7 seconds 914, a 2006 decision of the 5th District Court of Appeals. Gonzalez versus State, which is found at 948 7 seconds 877, a 2007 4th District Court of Appeals case. The cases which are cited within Huggins that came out of the 1st and 4th DCA, it's interesting to note that the case that came out of the 1st DCA, Worley, W-E-R-L-E-Y versus State, 814 7 seconds 1159, was written by then District Court of Appeals Judge Poston, who now sits on the Florida Supreme Court. Just be very, very careful when you elicit hearsay statements, because the aftershock of it can have a devastating effect. Okay, then we will be in recess to 9 a.m. I'd like to thank both the state and the defense, particularly our court reporting person, Ms. Peters, for laboring late at night to get this out. I think the last email came about 10:30 last night. Okay, we will be in recess. Be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorney, both sides ready to proceed.
Good morning, Your Honor. Yes, sir.
All right, good morning, Mr. Baez. Let's return Ms. Heisinger, and she, I believe, is up for cross-examination.